Welcome to The Explainer. Today, we're diving deep into one of India's most powerful, and let's be honest, most stringent laws, the Narcotic Drugs and Psychotropic Substances Act of 1985.
So, what exactly is this law? I mean, you've probably heard its name thrown around in the news, right? Usually tied to some high-profile case. But here's the thing. This isn't just a law for celebrities. Nope, it's pretty much the single most powerful piece of legislation governing drugs in India. And trust me, it affects everyone.
Okay, so if you look at the law's official purpose, right there in the preamble, it says it's an act to, well, basically create a super strong legal framework to control and regulate everything to do with narcotic drugs. And the two words you really need to pay attention to are consolidate, which just means it brought a bunch of older laws under one big umbrella, and stringent. And stringent is putting it mildly. This law means business.
All right, so here's our game plan for today. We're going to cover what this law is all about, what it actually forbids, its really unique tiered penalty system, how it's enforced, and then we'll look at what it does beyond just, punishment. Okay, first up, let's talk about the foundation. Because to really get a grip on how powerful this law is, we have to look at the specific words it uses. The language is key. So right from the get-go, the Act casts this incredibly wide net. It defines a narcotic drug as basically everything. We're talking raw plants like coca, cannabis, opium, all the way to any drug that's manufactured from them. And that is absolutely intentional. That broad definition is designed so there are zero loopholes.
And then on the other side, you have psychotropic substances. Now, don't think of these so much as plant-based drugs. Think of them more like a very specific list of chemicals, either natural or synthetic, that affect the mind. And here's the clever part. This list isn't fixed. It's a schedule that the government can and does update. So as new designer drugs pop up, they can just add them to the list. Pretty smart, huh?
All right, so the law has this super broad definition for the substances. But what can you actually not do with them? Well, it all boils down to one absolutely critical part of the Act, Section 8.
Section 8 is really the heart and soul of this entire law. I mean, just look at this list. We're talking cultivating, producing, possessing, selling, transporting, even just using or consuming it. Unless you have a very specific government license, say for medical or scientific reasons, pretty much any interaction you can think of with these substances is flat out illegal.
And that, of course, brings us to the really sharp end of the stick, the penalties. And let me tell you, they are severe. They're based on this very unique system that is the reason this law is considered so incredibly tough.
You see, this law isn't a one-size-fits-all kind of deal. It's not just about what you did, it's about how much of the drug was involved. The Act literally breaks down offenses based on whether the amount is what they call a small quantity, a commercial quantity, or, something in between those two.
And this table here lays it out perfectly. Let's just take cannabis possession, for example. If you get caught with a small quantity, you might be looking at up to a year in jail. Okay, but if that amount crosses the line into what's defined as a commercial quantity, the penalty just explodes. We're talking a minimum of 10 years of rigorous imprisonment. The difference is absolutely staggering. It's night and day.
Yeah, you heard that right. A minimum of 10 years. Let that sink in. And it's not just any old jail time. It's rigorous imprisonment, which actually means hard labor as part of the sentence. For these commercial quantity offenses, the judge's hands are tied. They have zero discretion to go any lower. This mandatory minimum sentence is really what gives the Act its teeth. And believe it or not, in the most extreme cases, the law goes even further than that. For repeat offenders, people who are convicted again for major trafficking crimes with huge quantities, Section 31A of the Act actually brings in the death penalty. That's what makes this one of the absolute strictest drug laws on the entire planet. So when you have penalties that are this severe, it makes sense that you'd need a pretty special system for enforcement and for prosecution, right? Well, the Act sets up exactly that.
The whole process is laid out very clearly. First, an empowered officer makes the seizure and the arrest. Then, and this is a really important check on their power, they must report all the details to their immediate boss within 48 hours. From there, the case moves on to a special court that was designed specifically to handle these kinds of trials. And these special courts are a really big deal. The whole reason they exist is to fast-track these serious cases. And crucially, to make sure they're heard by judges who have a ton of experience in this very complex area of law.
But
Once you're inside these courts, one of the most controversial parts of this entire law comes into play. It's a legal concept from Section 35, and it's called the presumption of culpable mental state. And let me tell you, it completely flips the script on how a normal trial works. So what on earth does that mean for the person accused? Well, think about it. In most criminal cases, you've heard the phrase, innocent until proven guilty, right? Well, under this act, that's turned on its head. The court automatically presumes you had a guilty mind. It assumes you intended to commit the crime. So the entire burden of proof shifts. It's no longer the prosecution's job to prove you're guilty. It's now your job to prove that you are innocent. It's a huge, huge difference.
But the act isn't just a giant hammer. I mean, it mostly is. But tucked away inside it are a couple of provisions that go beyond just punishment. They offer a slightly more nuanced approach.
It's kind of like two sides of the same coin here. On one side, you have Section 64A, which actually offers a path to rehabilitation. It says that an addict who's charged with a minor offense, like consumption or possessing a small amount, can get immunity from being prosecuted if they volunteer for treatment. That's one side. But on the other hand, you have Chapter VA, which gives the authorities the power to hit traffickers right where it hurts, their wallet. It lets them seize any and all property and assets that came from the drug trade.
And all of this leaves us with a really big question to chew on. Is the super rigid quantity-based structure of the NDPS Act with its mandatory sentences and reverse burden of proof, is it an effective weapon in the war on drugs? Or does its sheer severity actually get in the way of delivering justice that's, tailored to the specific person and their situation? That is the central ongoing debate around this incredibly powerful law.